Good afternoon, and welcome to today's webinar, COVID Happened, Do I Have to Amend My FDD? This is the first of Manning Fulton's Franchise Feed webinar series designed to provide you, as franchise executives, with relevant, actionable guidance on how to grow and protect. My name is Richie Taylor, and I lead the Manning Fulton Franchise Law Practice. As one of the leading franchise law practices, Manning Fulton's experienced practitioners focus daily on helping each client grow and develop their brand through franchising. It is now my pleasure to introduce my colleagues, Ashley Nielsen and Carly Smith, both franchise attorneys at Manning Fulton. They will be guiding you through today's topic to better understand what effect disturbances caused by COVID-19 might have on your brand's franchise disclosure, document, and development activities. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane on the control panel. You may submit questions at any time during the presentation, which questions I will collect for our presenters to address at the end of the program. If we are unable to address your questions during this session, we'll contact you directly afterwards to discuss them with you. Today's program will be recorded, and in the coming days, you will receive a shareable link to review this program, which can also be accessed along with other resources at franchisefeed.net. Now I turn the time over to Ashley and Carly for today's program.
Hi, my name is Carly Smith. I'm glad that you're joining us here today. When I traveled to the International Franchise Association convention in February of this year, it was about the middle of the month. Remember, as we were getting on the plane, we had heard us talk about those first few cases of coronavirus being discovered in the United States, and kind of thought, I wonder if I should be wearing a mask. And I don't think anyone anticipated that masks and social distancing would be the norm 6 weeks later, that the World Health Organization would have declared a pandemic and that the United States would be in a national emergency. To top it all off, for those franchisors who have a December fiscal year end, March and April are the times that they are wrapping up their annual updates and submitting them and finalizing their 2020 FDD. Those 2 months were kind of the peak of the uncertainty and government restrictions and confusion about the impact of the coronavirus. I think at the time, most franchisors proceeded with their registrations as normal, but realized that there were a lot of lingering questions about how the pandemic would affect the 2020 FDD and beyond. Now in September, we have more perspective and a little bit more guidance on some of those questions, and we're hoping to answer them a few today. So we appreciate your time to discuss these with us. So the requirement to amend originates with both the federal rule and state law. Franchisors have a perpetual obligation to make sure the disclosures in their documents are material and accurate, and the law encourages this both by requiring annual updates and then requiring an amendment in the middle of the year if there has been a material change. According to the Federal Trade Commission guidance, a material change is understood to be one that is likely to affect consumers' conduct or decisions with respect to the product, or in this case, the investment at issue. Another clarification they provide is that materiality is determined from the viewpoint of the reasonable prospective franchisee. You can find similar language in some state laws. For example, Virginia state law has defined material change as including a fact, a circumstance, or condition that would have substantial likelihood of influencing a reasonable prospective franchisee in the making of a decision related to the purchase of the franchise. In short, franchisors need to put themselves in the position of the prospective franchisees when they are determining what is material. This exercise of determining materiality is not unique to this amendment process. It underlies the entire disclosure document and franchise sales laws. The same types of analysis that you and your counsel use to make decisions about initial disclosures in the FDD will be used to determine the need to amend due to a material change. On that note, materiality is a fact-intensive and franchisor-specific inquiry. What may be material for one franchisor may not be material for another. The FTC does not provide a lot of specifics to guide your interpretation of what a material change is, outside of a few examples, which are a bankruptcy petition or a new legal action against the franchisor, which may have a negative impact on the franchisor's financial condition. But state statutes give non-exclusive examples. So the slide you see before you is a summary of some of those examples contained in state statutes. The first material change is a failure to renew or the termination of a certain number or percentage of franchisees within a 3-month period within a certain area, whether that's just within the state or across the whole system. The threshold in each state is a little bit different, so you will need to verify the laws in the states where you are registered. However, a good rule of thumb is that the permanent closure of 2 franchises in the same state, 5 system-wide, or 5% or greater throughout the system is probably going to trigger an amendment. The second example is related, except that the departure of the franchisee is a result of the franchisor's purchasing the outlet rather than just a termination. The statutory example also suggests that a significant change in the number of transfers between franchisees and new owners could also be material. The next example is all about the fact that the franchise need to understand the key operations and offerings of the business, especially if changes will require them to invest more money. Let's use the example of an educational franchisor that now offers online classes in response to the pandemic where it did not before. The change may require new technology platforms, elimination of other programs that are focused on in-person gathering, a new investment to cover costs in the curriculum changes and resources offered to students. The operational change might alone be material, but that's even more significant and more likely to be material when these innovations require hundreds or several $1,000s of additional investment. Next is change in the franchise fees that you're charging. This could be in item 5 or item 6 of your FDD, whether that's fees that the franchisor is charging before the franchisee opens, or fees that are part of the ongoing relationship. Using the online classes example again, if the franchisor is now the middle provider of the software that its franchisees are using, and it charges franchisees directly for that service, that would be an example of a change to item 6. Any change in the nature of your business operations or your relationship with the franchisee that's reflected in the franchise agreement, of course, needs to be updated. The next example is about a change in the franchisor's management. If the franchisor has had officers, directors, or managers that have changed over the course of the year, that will need to be reflected. The significant adverse change in the financial condition of the franchisor is a very business-specific inquiry because each business has a different capital structure, revenue stream, and degree of liquidity. Illinois has an example in its statute of a 25% decrease in net income or net worth as an example, but a much smaller percent change for your business could be material, especially if you are an emerging franchisor. Most franchisors probably have experienced some degree of change this year in their financial condition, so you should consult with counsel about how your current financial status compares with what you disclosed in the 2020 FDD. Any new litigation initiated against the franchisor or that the franchisor initiates should be evaluated against the rules to determine if it needs to be required in the FDD. The last factor is a little bit of a catch-all, and it relates to just the relationship between the franchisee, its suppliers, and the goods and services that the franchisee is offering. Maybe you've added new suppliers or altered existing supplier relationships to accommodate the pandemic, or the goods and services that you might be offering may have changed. For example, a gym franchisor might also offer childcare or more like spa services in conjunction with fitness equipment and fitness classes, but new laws might restrict the offering of those supplemental services. As we look at all of those state factors, a material change that's important to your business might not be listed, or it might not be listed in a certain state statute. So the good rule of thumb is that if it's considered material in one state, it's material change under the federal law and other state laws as well. So what do you do once you've determined that there is a material change? If you are not selling in any registration states, you are subject to the FTC rule, which requires an update after a reasonable time after the close of each quarter of the fiscal year. The brunt of the pandemic's closures and restrictions seem to have been in the first and second quarter of 2020. And now in September, franchisors have had a reasonable opportunity to evaluate the changes in their systems and should move forward with the amendment if they determine it's required. State laws require the amendment to be filed more quickly. Common language that they use is within 30 days, promptly, immediately. So if you registered in the registration states this year and have a material change, you should not delay the amendment process. I will note that item 19 and the financial performance representations contained therein have always been subject to a high degree of scrutiny regarding materiality, accuracy, and reasonableness of the disclosures. So under the FTC rule, if you have a material change to item 19, but have not yet incorporated it into an update or an amendment, you need to provide notification to the franchisee of the change when you disclose them with the unamended FDD. Franchisors have the burden of showing that they did this, and so it should be in written form. Of course, our best advice and recommendation for avoiding unnecessary risk is to stop providing the unamended FDD to prospective franchisees once you determine that there is a material change, especially to item 19. In June of this year, the North American Securities Administration Association issued some additional guidance to the changes that COVID-19 has brought. Ashley's going to discuss a lot more in a minute the details of this guidance, and a lot of it relates to item 19, but there are a few items that are broadly applicable. First, franchisors need to evaluate changes in how their businesses deliver goods and services. So restaurants are an example of having to pivot to implementing delivery and takeout services, whether for the first time or to a much larger degree than they have in the past. Brands might be emphasizing and relying on the online sale of products. You might have appointments for services rather than walk-ins, or you might provide opportunities for customers to use products and services in their homes rather than in your traditional retail space. Second, you need to consider the impact of local laws and safety guidelines on how you conduct business. You may now have limited capacity or altered hours. Some types of brands might even still be limited in their ability to open and operate at all, for example, bars or certain entertainment venues. Another example is a significant cost increase to operate with new sanitation or safety procedures. Some of these changes may have been limited to the spring and the summer, but others are going to linger throughout 2020 or may become part of the system for the foreseeable future. In fact, I hope some of you have found that the innovations that you've had to take on because of the pandemic are things that you want to keep in your system and make it a better system overall. So if any of the changes are more than temporary, it probably qualifies as a material change. Once you determine that there is a material change, the amendment is going to probably affect multiple parts of the FDD. Let's use the example of the franchisor who's partnering with a third-party delivery service, maybe for the first time during the pandemic. And new franchisees will be required to use this service as well. So any new fees that are associated with this could be reflected in items 5 and 6. And then the cost of implementing this new service, it will probably be implementing from the beginning and involve additional investment that needs to be disclosed in item 7. Item 8 will need to be updated because you now have an important new supplier with the delivery system. The delivery service might require new technology or additional training, and that's going to be reflected in item 11. Item 12 might need to be modified to account for delivery to customers outside of the franchisee's territories. As mentioned before, any new limitations on what the franchisees offer need to be updated, and that can be done in item 16. And then just back in item 1, as a general point, Whereas in item 1, you have the opportunity to list relevant laws that apply to your business. And if there are new restrictions about operating that your franchisee should be aware of, that should go in item 1 as well. Finally, please note that in many registration states, you will need to include unaudited 2020 financial statements in the amended FDD with item 21. And similarly, that will be required if you determine that there's been a material change in the franchisor's financial condition. Franchisors need to consider these factors now, but they also need to keep them in mind throughout the remainder of 2020. We've learned that with this pandemic, things can change from week to week and day to day. And so as you experience changes and have to adapt in your franchise systems, you may determine that later on you have a material change as well. So with that, I will turn it over to Ashley.
As Richie mentioned, I am Ashley Nelson. I'm an attorney at Manning & Fulton. Today I'm going to talk about item 19. Oops. Today I'm going to talk about item 19. As a refresher, this is a portion of the FDD where franchisors may choose to disclose the historical financial performance of their company-owned and franchised units. As a refresher, if I say FPR at all during this presentation, I'm referring to financial performance representations that are made in item 19. FPRs and item 19 are of course heavily regulated in franchising, such that a franchisor or its representatives may not make financial disclosures or projections to prospective franchisees unless those disclosures are included in item 19 of their FDD. Even then, what is contained in those FPRs and how those FPRs are presented is heavily regulated by the FTC in various states. Again, as a refresher, Carly mentioned NASA and their new guidance. I think it's always worth pointing out that when we're talking about NASA, we unfortunately are not talking about spaceships, but are instead talking about the North American Securities Administration Association. This group is comprised of regulatory officials from throughout North America, including state franchise regulators. So some of the people on the committees that make up the franchise project group for NASA are the exact same people who are reviewing your FDDs. As a reminder, NASA frequently provides interpretation of the FTC rule as well as other guidance and commentary that is often adopted by registration states. As most of you probably remember, NASA provided commentary in 2017 about item 19 and financial performance representations. As you might recall, that commentary addressed things like subsets. It made you add medians whenever there were averages and high lows. So again, I'm sure you all recall that. So the guidance that they issued in June is similar to that commentary that NASA issued in 2017. So what we're going to be talking today about is the NASA guidance issued. The title of it was the NASA guidance issued for historical franchise performance representations reflecting COVID-19 impacts. So you might be wondering, why did NASA issue this guidance and why the focus on item 19 specifically, when, as Carly mentioned, there are plenty of other places in the FDD where franchisors need to consider amending. This is a good question. Some franchisors and many franchise attorneys would argue that COVID-19, while certainly unprecedented, is not all that different from hurricanes and other natural disasters that wreak havoc on franchisees and their earnings short term. A few weeks ago, as Carly and I mentioned, we were able to, she mentioned the IFA convention. A few weeks ago, we were able to virtually attend the International Franchise Association's legal symposium. And we were pleased to be able to hear from state regulators and hear their reasoning and purpose behind issuing this guidance. It was very helpful to hear them talk about their purpose behind issuing this. Again, because we kind of had that question of why focus on item 19 specifically. Dale Cantone of Maryland explained that the regulators viewed COVID-19 as something that would significantly impact many franchises for several months and possibly years to come. Many businesses are making permanent and significant changes that will last beyond the pandemic. Unlike with hurricanes or strikes or other natural disasters, they do not view COVID-19 as an event that will have a short-term impact for many franchisees, but one that will have long-lasting effects. And so for that reason, they thought it necessary to address item 19 for the benefit of state regulators and also for the benefit of franchisors. So what does the guidance say? The guidance very clearly and quickly dispels the notion. Well, to back up, the guidance talks generally about the idea that franchisors need to think very critically and carefully about whether or not they need to make amendments to their FDD and specifically to the financial performance representations that they make in item 19. The guidance very quickly dispels the notion that a franchisor has a reasonable basis for disclosing an FPR simply because the FPR is historic and accurate. The regulators made it very clear in their presentation that they did not enjoy receiving comment letters back that argued about the historical accuracy of item 19. They said that that was never the standard. Specifically, the new NASA guidance says, under some circumstances, an FPR that discloses historically accurate data may contain an omission of a material fact or an untrue statement of material fact if material changes have occurred to that FPR by the time it is provided to a prospective franchisee. According to NASA and the state regulators, we heard a couple weeks ago, historic has never been a sufficient standard for disclosing FPRs, and neither has accuracy. FPRs can be historically based and accurate, but still misleading. A few examples to illustrate this point: providing subsets of your franchisees, such as cherry picking, or showing only the top 10% of performers without disclosing the bottom 10%, is indeed historic and accurate, but is misleading. And that's something that, as you'll recall, the item 19 commentary in 2017 addressed. A more current example, and what the regulators were really trying to get at with this COVID-19 guidance, is the example is, if you operate a gym franchise that operated until 2020 as a traditional brick and mortar business, it would be misleading to provide those 2019 numbers if you completely change the business model so that franchisees no longer operated brick and mortar businesses but held virtual or online classes only. So again, in that example, where you move all the classes to virtual or offsite classes, technically the 2019 numbers would be both historic and accurate, but according to the regulators, NASA, and their view of what the FTC rule itself says, is that those numbers would actually be misleading because they would give a false impression of what a prospective franchisee could expect to make based on your item 19. Okay, so the factors to consider. The guidance has some a very specific list of factors that you should be considering when you're contemplating whether or not to amend your item 19 based on the impacts of COVID-19. The guidance lists the following factors. The first one is whether the franchise business has been significantly impacted by the COVID-19 pandemic. The easy example in this case would be closures of your franchisees' businesses, or having to make substantial changes, or allowing capacities of only 50% for restaurants or gyms. Not all businesses have been significantly impacted by the COVID-19 pandemic, and in those cases, you do not need to update your item 19, but most probably have. So this factor probably relates to most businesses. The second factor to consider is the type of data the franchisor includes in the FPR. This is really important. The regulators said in the IFA Legal Symposium plenary, they said very specifically that a comment that they were often receiving from franchisors and their counsel was that there were no material changes in the industry. And so for that reason, the franchisor did not think that they needed to amend item 19 of their FDD. However, the regulators made it very clear that you need to think very critically about whether your brand specifically and your specific franchisees have been impacted in a way that would materially change your item 19, not just whether the industry has generally experienced any change. And this, it comes down to your specific brand and your specific franchisees, but it also comes down to the specific information that you've disclosed in item 19. So for example, maybe your franchisee's profitability has not suffered as a result of COVID-19 because you have innovated and adapted. But if the franchisee, if your FPR in 2019, or based on your 2019, was based on how many customers you were receiving, like you actually made an FPR that included customer count or number of tickets, in that situation, you would need to amend your FDD if those numbers were altered, even if the profitability wasn't. So again, you need to think critically about whether the item 19 that's currently in your FDD, whether the specific data that was disclosed would be materially changed at all as a result of COVID-19. The third factor is the reasonable inferences a prospective franchisee can draw from the FPR. I kind of smiled when I first read this one. I think we need to make clear that this factor does not mean that you're free to choose not to amend if a prospective franchisee could reasonably infer that the numbers are no longer representative or reliable. I think it's worth noting that while Carly said materiality is based on what a reasonable prospective franchisee would think, I think for purposes of deciding to amend this year, you perhaps should consider that reasonable franchisee to not be so reasonable and to not even know that COVID-19 is going on. I think you'd probably be safe in that case. So again, you do need to consider the reasonable inferences, but again, it's not enough that you can look at your FPR and say that any reasonable franchisee would know that those 2019 numbers are inaccurate now, or unreliable, or that you have no reasonable basis for making them now or for disclosing them now. Generally speaking, if you're painting a picture that is no longer true, then you need to amend. I think that's what this factor is really getting at. The next factor is when the franchisor estimates a prospective franchisee can expect to open for business after entering into a franchise agreement. This factor, I think this factor is interesting, but I do think you need to be really careful with this one because at the end of the day, none of us have any idea how long this COVID-19 pandemic is going to last or what the ultimate economic impact it will leave on your system. So with this factor, and again, it's also worth noting that this guidance was again issued in June, when I think we were all a little bit more optimistic about how long COVID-19 and its impact would last. I think now that we're in September and we're still we're not necessarily through the worst of it, or arguably are not through the worst of it. I'm curious if they would put this factor in there now. However, I think it is worth thinking through this factor. I suppose theoretically you would have a stronger argument that you do not need to amend your FPR that contains pre-COVID-19 numbers if your franchisees take a couple of years to open after signing their franchise agreements. However, I have not had the chance to test this argument out with regulators, and I seriously doubt the regulators will give you a free pass if your business has otherwise been significantly impacted by COVID-19. The next factor is whether and how the franchisor adapts the franchise business to account for current market conditions resulting from the COVID-19 pandemic. Basically, if you have changed your business model entirely during COVID-19, then you need to amend your FDD, assuming any prospective franchisees again will open their businesses soon after signing or during what would be the foreseeable future of the pandemic. Whether the very last factor that they list is whether and how the franchisor adapts the franchise business to account for future market conditions resulting from the COVID-19 pandemic. So again, if you've completely changed your business model in permanent ways that will extend beyond the pandemic, you not only need to amend, but as we'll discuss in more detail in a minute, you really need to think about removing your 2019 numbers altogether. Okay, so what are your options as a franchisor? So obviously one of your options is to make no changes. I do want to make it very clear that not all franchisors need to amend their item 19. However, I think it's clear both from the guidance itself, but also from the discussion from the regulators at the IFA Legal Symposium, that there is going to be a bit of a rebuttable presumption from regulators that you need to be thinking about. You at the very least need to be thinking about, but there's probably a rebuttable presumption that you need to remove, or sorry, that you need to amend your item 19 to account for COVID-19 changes. It sounded like if you choose not to amend, you need to actually be able to show and possibly prove to state regulators that you in fact have not experienced any material changes to your item 19 as a result of COVID-19. So I think it's very important, whether you think you need to amend or not, to pull the numbers, because as we'll discuss in a minute, even if you choose not to amend now, especially if you're going to face regulators at the end of your after the end of your fiscal year, at that point, the regulators will have a chance to comment. They'll be looking at your last item 19. Again, you might at that point have to prove that you weren't supposed to amend back in September of 2020. So pull those numbers and look critically at them. So again, that is an option, but you need to be very careful about choosing that option. Option 2 is to remove item 19 altogether. There are a couple reasons you might do this. If you no longer have a reasonable basis for your 2019 numbers, and you don't want to disclose your 2020 numbers because they might not be super great, then you obviously need to remove your item 19. Some franchisors who may have decent numbers and maybe even 2019, they don't consider those unreliable, unreasonable to disclose anymore. They still might choose to remove item 19 just to save on costs and time. I think this is something you really need to think about when you are making this analysis. Properly amending your item 19 to account for COVID-19 changes will not be as simple as copying and pasting new data into your pre-existing charts. Properly amending is going to require that you tell your story about how COVID-19 has impacted your system, and it's going to take extensive changes. So from a legal cost perspective, that's something that some franchisors might choose to forego. But what might be even more pressing for franchisors is getting registered in registration states. If you are in a registration state or multiple registration states, you will need to send your amended FDD to the states for approval. I don't mean to be pessimistic here, but we don't anticipate that this will be the fastest process. It's very clear that regulators really, and rightfully so, want to make sure that item 19, that they're not misleading. And so we believe that they'll be looking at these item 19s that they'll be coming through them very carefully. So we don't know that this is going to be the fastest process. And so if you're in the middle of discussing sale, or if you're in the middle of the sales cycle with franchisees, or you think you will very quickly, it might be worth considering removing your item 19 altogether just to get through the approval process quickly when you do send that amendment to the states. So we believe many franchisors will choose to remove their FDD in part because they do not want to halt their sales processes for several months while the FPR makes its way through the various state approval processes. Something too that we're a little bit concerned about, again, we haven't gotten to the end of this process yet with regulators, so we're just kind of anticipating how it might go. We have seen, so far we've seen that the removal of item 19 tends to make the approval process really quick. But as you probably know, if you're registered in a lot of states, various states will view item 19 with more scrutiny than others. So there will be a lot of variance between the regulators and also a lot of variance on the time involved. And there is a lot of risk and we would not recommend having an item 19 that's different across the states. That you really should have your item 19 be uniform across the states. So that's the other risk, is even if one state approves your item 19, you're good to sell in that state. It could be in a bad spot if another state then decides that there's some issue with the way that you've amended item 19 and you've sold a franchise in the first state. So again, for that reason, it's just something to think about. You really need to think carefully about where you are in your sales process and whether you're willing to halt that for several months to get these changes approved. Furthermore, of course, removing your item 19 may unfortunately be the only option for you if you need to amend and you do not have up-to-date information from your franchisees. For example, if you collect them on an annual, you collect sales data on an annual basis only. So this is a good time to start maybe improving those processes for receiving data from your franchisees, because you will need them now to amend, but also, as we'll kind of talk about, or as Carly mentioned, we might have to amend, you might have to amend, multiple times. It's possible throughout this COVID-19 process. And because of that, again, getting accurate and up-to-date sales information from your franchisees is important if you want to continue to accurately and legally disclose FPRs. Your third option is to revise your item 19. When you do this, you have a couple different ways of doing it. First, you need to look at what's already in your item 19 today. You need to look at your 2019 and FPRs and any FPRs that you've made prior to that. And you need to think about whether you still have a reasonable basis for disclosing those old numbers. For example, you would not have a reasonable basis for disclosing those old numbers if your system has fundamentally changed in a way that is permanent. So, and in a way that would, again, materially impact those FPRs. Again, another example, if you have a reasonable, if you can reasonably foresee that customers will never react the same to your industry again, then you should also probably consider just removing altogether. So you really, the first step in this analysis, if you are choosing to amend rather than removing, is to consider whether you can keep your, and I call it 2019 FPRs, but really anything pre-COVID. So that would also go into the beginning of 2020 as well. Now your 2020 FPR, and again, what I really mean here is your post-COVID numbers. In order to add those, you need to think about how you want to tell your COVID-19 story. So there's no one right way to do this, to disclose these 2020 numbers. But we do think it's best practice, and from the regulators seem to agree with us, not only in protecting you legally, but also in trying to sell your franchises. We think the best practice will be to show month-to-month data. This allows you to tell your COVID-19 story in detail, and also very clearly shows the regulators and prospective franchisees how COVID-19 has impacted your business, and how it varies from by month to month, and how it's evolved as the pandemic has evolved. You will also likely want to include, so if you go this route, you'll also likely want to include as much information as possible in your item 19, again, to protect you from lawsuits from future franchisees, and to best tell your story. We anticipate that, again, I do not think that if you go this route, we would not recommend that you just simply drop the numbers into the table that's currently in your item 19. We think you should consider very carefully explaining what's happened to your system, and why the numbers have gotten to where they are. For example, you may want to consider reorganizing your data in a way that shows how COVID-19 has impacted various regions differently than others. For example, some of your franchisees may have returned to operations months ago, while many are returning to normal now. For example, the gyms in North Carolina just reopened, while gyms in Utah have been open for months, but at a limited capacity. So you might want to think about whether you can group your franchisees in a way that shows that story, or identify franchisees that have been impacted uniquely because of COVID-19. This is the example that the regulators showed at the IFA Legal Symposium. This is what they considered to be a good FPR that takes into account the impact of COVID-19. Again, as I mentioned before, month-to-month data is in the chart that clearly shows the impact of COVID-19. I thought it was interesting to note in this example, while I agree that it is probably best practice, One thing that is not always advisable that's on here, and again, it depends on the franchisor. One thing that's not always advisable or possible for a franchisor is to show location by location data, and especially to identify the location. That's not going to be advisable. It's not really going to be optional for franchisors that have huge systems, and it's probably not going to be advisable for franchisors who, you know, don't want to be showing their playbook of where their best locations are to their competitors. So there's going to be some tension here between wanting to show the whole story of what's going on with COVID-19 and how it's impacted your franchisees on a franchisee by franchisee basis, with also wanting to protect your brand's playbook and keep that from your competitors, who of course would have access to your item 19 and FDD. You and experienced legal counsel may need to get creative about how to effectively, legally, and accurately represent your brand story while not disclosing information without sharing your brand secret information. So the risks of not amending. Risks of not amending. Again, you are at risk for getting a comment letter for not amending if you are in registration states, or if you think you will be next year or in the next several years, and you don't amend now, you will almost certainly have to face the regulators when you update your FDD after the end of your fiscal year. You will not only receive comments asking you why you didn't amend, but you could, worst case, get banned from offering franchises in that state. They could also require you to offer rescission to all the franchisees that you sold franchises to in that state, which would be messy, time-consuming, expensive, and risky, obviously, if the franchisees do, in fact, decide to exercise rescission. So again, you need to think very, very critically about why you're not amending if you do, in fact, choose to do so. And we recommend really documenting, why it is that you choose not to do that, so that when you face those regulators during your next update cycle, you are prepared to respond to those comment letters. Finally, the biggest risk is that you could get sued by prospective franchisees, any of these franchisees that you're selling franchises to now and throughout the pandemic. Some of you may be thinking that this NASA stuff doesn't apply to you because you're not in registration states, and maybe you don't have any plans to go into registration states for a long time. However, it's important to remember that while many states have not formally adopted the NASA requirements or the NASA guidance, NASA, as well as many courts and franchisee attorneys, view this NASA guidance as best practice for all franchisors in the United States. It is not NASA's view that they're adding any new requirement with this guidance. Rather, and this is important, they think with this guidance that they are merely interpreting the FTC rule that applies to all franchisors who sell in any U.S. State or territory. For this reason, we believe the June guidance will be cited extensively in any fraudulent earnings claim a franchisee makes against a franchisor for sales it made to the franchisee during the COVID-19 pandemic. And with that, I will turn the time back over to Carly to discuss the next steps franchisors should take following this webinar.
Thanks, Ashley. So now we've talked about how you should be thinking about amendments, why they're important and what they are, and these are some next steps. So first, gather information about the impact of the pandemic on your system. I think some of the highlights are going to be permanent closures, financial positions of the franchisor, the 2020 performance of the outlets that you've disclosed in item 19, and changes in your business practices and operations. If you don't have easy ongoing access to franchisee financials, you will need their cooperation to undertake this 2020 mid-year review of the data. Second, work with counsel such as Richie or Ashley or I to determine if the changes are material. You may decide that no update is necessary. However, you need to be able to document and provide this rationale to a franchise examiner in 2021. The more evidence you have, the better. Third, pause your sales pipeline if you've determined that the amendment is necessary and while you prepare it. and work with counsel to get that amendment ready and submitted to the states, and then resume your sales process with the effective amended FDD. Know that pausing and resuming the sales process is not convenient, but it's an important way for you to mitigate important risks. We don't want any litigation against the franchisor to show that the franchisor knew that an amendment was necessary or recommended, but continued selling and closing sales with an unamended FDD. So just in sum, collect information and talk with your attorney. And that wraps up the major portion of our presentation today, and we're ready to take your questions.
Thank you so much for your presentation. We now have a few questions that the first question is there a need to update item 20 even though it represented prior year's snapshot? Do you need to disclose all closures that aren't temporary?
So I can take that. The table portion of item 20 includes data from the previous 3 years. So in 2020, it's 2017, 2018, and 2019. And that portion will remain the same. However, there's a second portion where you describe the franchises that have been terminated, or you lost contact with them, or they've left the system in some way between the end of that fiscal year and the current date of the FDD. So the latter portion would need to be updated to account for the 2020 changes to your franchises, but the table would not.
And I think that's where you're seeing most people having to update is on the exhibit listing the former franchisees who left the system because of the large number that might have left the system or been permanently closed. So why do I need to go through all this trouble when prospects already know that COVID has wreaked havoc on my business? Can't I just add a COVID-19 disclaimer, Ashley?
It's a great question. It tends to be one of the first questions that we get from clients. That is something that has been addressed very, very thoroughly by NASA and the FTC really since the rule was promulgated. Disclaimers are very strictly prohibited in item 19. Anything that starts with we cannot project or we cannot predict is strictly prohibited. I like to, and to contrast that, it doesn't mean that you can't provide franchisees with information. So you're allowed to provide information that provides, that elaborates on your FPRs, but you're not allowed to say anything that would undermine or sow doubt in the franchisee about the accuracy or reliability of the data. So a good example of information would be to say something along the lines of, in 2020, due to the global coronavirus pandemic, some government agencies have ordered that our restaurants temporarily close. So that's a good example of information. Again, where a disclaimer is something along the lines of, we cannot project, we cannot predict, we don't know, anything that basically would say, we gave you all this information, but really you shouldn't rely on it. Those are disclaimers, and they're strictly prohibited. And franchise regulators just love to cross those out when you send in FDDs that have those in there. So what we anticipate is that experienced franchise attorneys will be adding a lot of information to item 19s this year. So again, I foresee many paragraphs, if not pages, of information in item 19s this year, but disclaimers are not allowed.
Can we amend our current FDD to show year-over-year comparison in item 19 to show a normal year versus a COVID year?
I think so. I guess you're saying year over year instead of month over month. Sorry.
Right. Sure. So yeah. So it would be. So you would show, for example, 2019's actual performance versus the COVID time period, or would you prefer that they, for example, do a more current period?
I'm gonna make the caveat that all attorneys make. I mean, it depends, and I'd like to see obviously the data and the materiality to be able to know for sure. I don't think regulators are going to like that as much because it doesn't show as much of a picture. And most franchisors, I'm not sure that that's going to be the best way to do it also, because again, you're going to be showing only part of 2020 instead of all of 2020. So again, I think it's going to completely depend on a lot of various factors that are going to be specific to your business. I don't think we can rule that out entirely as a way to do it, if that's the only information that you have. But I do think you'll want to add a lot of information to go along with that if you're going to disclose, year-to-date data instead of month-by-month data.
And if I can add to that, something y'all mentioned earlier in your presentation was, I mean, the regulators, since they're coming at this from a investor protection perspective, perhaps they might see the glass a little bit more half empty than half full when it comes to these kind of things. And so while you may be seeing in your particular business, the participants on this call might be seeing that they're returning to normality and or even exceeding those expectations. Is actually noted, and they were writing these rules during April and May when they promulgated them in June. Half the country was shut down, and so they're still perhaps coming at it from a pretty pessimistic point of view. And so the risk you run with that normal year of 2019 against the COVID year would be that we would have to make the argument to the regulators that COVID-19 was purely an anomaly, which some businesses may be able to show that, because some of our clients have seen, or they might have had bad Aprils and Mays, but they had great June and Julys. And if as that trend continues, that might that case might be able to be made. So part two of that question: can we itemize any PPP or Paycheck Protection Loan proceeds received under income?
I think you can, as long as it's disclosed. I can't make any promises about whether regulators will be accepting of that. The issue is going to be if you have disclosed income in a specific way throughout your FDD historically, where something like PPP loans would not be included, then we would not recommend that. But if if you've disclosed gross sales or gross revenues in a way that could include something like PPP, so maybe you've always included something like proceeds from business disruption insurance as part of the definition of gross sales, and you've always included it as such, then you probably can. Again, that doesn't mean regulators will love that. And in any case, we definitely would recommend that you include a lot of information and a lot of footnoting in that situation to kind of clarify that for prospective franchisees.
Right, and also I think the issue is going to be that you're going to run into is that they're going to say, well, that program is no longer available for prospective franchisees to take advantage of. In fact, they wouldn't be able to take advantage of it because they opened their business after February 15th, so they wouldn't qualify. So that would be one issue with it, but you may be able to show that as income and then in turn carve it back out, so just to acknowledge that it was received. Another question was, are the states requiring new auditor consents with amendments, especially if the franchisor's financial condition has deteriorated? I think the answer there is if the auditor would be such that they would be revoking their financial statements, then yes, you'd have to get an updated consent, or they'd be caveating it because of a subsequent event. And yes, deterioration in the financial statements. Carly, I think you spoke about that, about deterioration in the financial statements. Do you want to elaborate more about that, when that could trigger an amendment?
Yeah, just that at a certain point, it's not just a normal fluctuation throughout the business year of normal changes that you'd see in net worth and net income. And it's really hard to put a precise number on that, based on the type of business, the industry of the business, how long the business has been in operation. But if it's material and is causing you concern at the franchisor level, it would cause concern at the franchisee and prospective franchisee level. And so that's a good way to think about it. And, I think as Ashley mentioned, you don't want to overcompensate and provide more information than is really necessary, but that's probably going to be difficult to do in 2020 when things are so just unprecedented and the regulation approaching it is so new and uncertain.
And to that point, I mean, the materiality, as was noted earlier in the presentation, is going to be focused on what a reasonable prospective franchisee would find as important information in order to make a decision of whether or not to invest in that franchise. And obviously, those audited financial statements are one of 22 different disclosures, that main level disclosures that are provided. So they are most certainly extremely material to understand the creditworthiness of the franchisor. And so depending on how much those financials have deteriorated, the regulation states could require unaudited financials to be provided, and may want an updated consent as well, as was noted. And a 20% drop in an emerging brand with 50 locations, drop in their revenue would most certainly be material, I think, in most people's books, whereas that may or may not be material in McDonald's books because of the amount of equity that they have on their financial statements, and a lot of it has to do with balance sheet integrity as well, right? Because they're looking to see, does the franchisor have sufficient liquidity to be able to fulfill its obligations? Any other questions? So Carly, does this mean I'm going to have to amend my FDD multiple times a year?
It's a possibility. As you may discover material changes in September of 2020, and as you move along, might discover more in November 2020. And you should be able to be prepared to amend accordingly. We know that's, again, not the most convenient, but it's about protecting yourself as the franchisor and about giving accurate and helpful information to the franchisees that you're hoping will be brought into your system. As Ashley noted, the revisions to Item 19 can be a substantial process, and the risk of having to amend multiple times is perhaps a factor that cuts in favor of removing Item 19 rather than having much different financial data in September versus November versus January of 2021.
And the last question, Ashley, so you had mentioned weighing the risk of taking out the financial performance representations in Item 19. How do you weigh that risk against the risk of someone alleging that you made illegal financial performance representations due to the absence of the Item 19 disclosure?
Yeah, I agree. I don't think it gets rid of that risk. And what I'm particularly concerned about too is any sales that have been made, since March of this year up until now, when you decide to amend. Those are probably the sales that I'm most concerned about. So I agree. It doesn't that is a risk that's worth thinking about. So again, I don't think I'd recommend in all circumstances that the right option is to remove Item 19. But I do think you need to think thoroughly through the risks of including one that is considered unreasonable and unreliable. So again, if you do remove it, you do need to make sure that all your salespeople know that they can't make any financial performance representations. I'd recommend documenting that very clearly, that correspondence. Make sure that everyone's really well trained to not make them, and then that's probably the best you can do. But again, it doesn't get rid of that risk, of course.
Right, and for those who have locations out there, then obviously existing franchisees would be a resource for them to talk to, as in order to get more information about how the financial performance of the brand has performed during this time period. Obviously, you want to make sure not to steer people to specific franchisees on that.
Yeah.
So thank you. Sorry, go ahead.
Oh, sorry. I was going to say, Richie makes a good point that I think is sometimes forgotten, that if you choose not to make a financial performance representation, prospective franchisees are always welcome to talk to franchisees and ask any question they want about their earnings from those franchisees. Franchisors just shouldn't be doing much steering in that situation. Thanks, Richie.
Perfect. Thank you, Carly and Ashley, and thank you for everyone for attending today's webinar. If you have any questions regarding the information presented, please contact us and we'll be happy to discuss them with you. In the coming days, you'll receive a follow-up email with a shareable link to view the recording of today's program. On behalf of all of us at Manning Fulton, thank you for joining us today, and thank you to Ashley and Carly for this excellent presentation. Have a fantastic day.